In the Supreme Court of the United States, an emergency application for a stay coming up from Pennsylvania. They say the underlying courts have made a mistake and they ask for a stay and a writ of certiorari granted, meaning the Supreme Court, they want them to hear this case. And so we'll go through this because it's out of Pennsylvania. Some people say it's the Keystone State. It is the state that we need to win, and actually both sides need to win in order to win the election. The most important state, maybe, coming up. And so this is a battle over how the election will be conducted and how the votes will be counted. And you can see this one is going up to the Honorable Samuel Alito, excellent judge on the Supreme Court, as he oversees the Third Circuit coming out of Pennsylvania. They say, all right, weeks after mail voting began in Pennsylvania, Supreme Court judges, and less than 2 weeks before Election Day, a sharply divided 4-3 Pennsylvania Supreme Court, their highest court, left and departed from the plain terms of the election code law and dramatically changed the rules governing the mail-in voting. And the Supreme Court of Pennsylvania did so right in the middle of a general election in which millions of Pennsylvanians have already voted. Now let's talk about the law. The law says a provisional ballot shall not be counted if the mail ballot is timely received by county board of elections. A provisional ballot by a county board of elections. That's interesting. Could not be clearer. A provisional ballot shall not be counted if the elector's mail ballot is timely received by a county board of elections. But it is timely received. Undeterred, the majority below held that election officials must count a provisional ballot cast by an individual whose mail ballot was timely received, but could not be counted because it violated a mandatory rule, such as a lack of a signature, date, or secrecy envelope. This holding effectively creates a cure process for mail ballot errors, a process everyone agrees the General Assembly has deliberately chosen not to create. All right, so this should say not, is not, if the elector's mail-in ballot is not, right? Shouldn't that say not right there? Is what I'm trying to determine, because otherwise, is that right? We're just doing a quick search. Anybody see what I'm seeing there? A provisional, let's see. Okay, it says it shall not be counted in these situations. Let's see. Yeah, so I think what they're doing here is they're mashing together two different statutes. So here is the code. Yeah, okay. A provisional ballot shall not be counted if, no, it's right, the elector's absentee ballot or mail-in ballot is timely received by a county board of elections. All right, so it's right. It's right in there. And then there are other rules. The exceptions shall apply. All right, so let's see what it says. So as Justice Mundy explained in the dissent, the majority's ruling usurps the General Assembly's plenary authority to direct the manner for appointing electors. As the three dissenters recognize the election code is clear. And so this court bears the responsibility of ensuring the state courts do not unconstitutionally intrude upon the role specifically reserved for the legislature. So it's saying that basically the county board it's not about the timing, it's about the party. So by any standard, however deferential, that line has been crossed here. When the legislature says that certain ballots can never be counted, okay, at all, it says you cannot count them, even if they're timely received. A state court cannot blue pencil that clear command into always. Like it says, if it's timely, you're not counting it. And here, the General Assembly could not have been clearer. As the court explained in 2020, when it rejected the same arguments, our General Assembly, in clear and unmistakable language, dictated that in circumstances like this case, the provisional ballot shall not be counted. Like they said, you're not counting it, even if it is something that's come in on time. The Pennsylvania Supreme Court also made a mistake in changing rules governing mail voting in federal elections after mail voting commenced less than 2 weeks before Election Day. The Purcell principle, which is the one that we talked about that says you cannot interfere in a state election if you're a federal court when you're close to an election. Not to mention common sense says that when an election is close at hand, the rules of the road should be clear and settled. Whenever the temporal line, barring last-minute judicial rule changes, lies wherever it lies, this ruling below plainly crossed it. Nor is this a case where the court's intervention would somehow itself sow confusion or trigger remedial issues. No, in fact, to the contrary, a stay here would prevent the chaos because we've already said you cannot count those votes. This court should enter a stay. This is a case of paramount public importance, potentially affecting tens of thousands of votes in Pennsylvania that could lead to decisive control of the Senate or the presidential election. Whether that crucial election will be conducted under the rules set by the legislature or under the whims of the Pennsylvania Supreme Court is an important constitutional question. And if this Supreme Court fails to act, this is an egregious judicial usurpation of the legislature. Like the legislature, I don't know why they said that, but they did say it. Didn't even make sense to us. Wait a minute. If they get it by on time, okay, but I guess it's the county board. They don't want to get those ballots. Got to go somewhere else. Applicants thus respectfully request the court enter a stay pending disposition of this case. Given that provisional ballots may be canvassed starting on election day, time is of the essence. Applicants request that this court expedite its decision on this application. In particular, we request the court, as of yesterday, set a deadline, and that was met. So now we're waiting for Alito to decide and the court to decide. If the court determines a full stay is not warranted, then we ask that you order that provisional ballots cast by individuals whose ballots were timely received but invalid be segregated from all other ballots, and if counted, be tallied separately and not included in the official total. So if you're not going to pause this, then make them separate it. This court took the steps in 2020 to prevent mootness in another case in our state. And as that previous experience concerns, this is not going to prejudice anybody if you just make them separate this out. So let's look at some background on this. Now, in 2019, as part of an important bipartisan compromise, the General Assembly amended the election code to permit all Pennsylvanians to vote by mail without any excuse. Now, as part of the compromise, which was protected with an absolute non-severability clause, the bill also included certain rules that Pennsylvanians voting by mail must follow to have their ballots counted. And here, voters who cast mail ballots must seal them with a secrecy envelope, which protects privacy. Secrecy envelopes are then placed within mailing envelopes, bearing a declaration that voters must sign and date. All agree that these things, the envelope, the signature, and the date requirements are mandatory. If you fail to comply, your ballot is invalid and it is ineligible. Those are the rules. They set those rules back in 2019. The legislature and others, it was a compromise, right? See how this stuff happens? They negotiate, they come to a deal. Now, all agree, too, that the election code does permit Pennsylvanians to cast provisional ballots on election day. And so a provisional ballot is like it's not your real ballot. It's you got mailed a ballot, you lost it. You already have a ballot out there. So we have to make sure we're not counting that ballot and your new ballot. It's like you show up on election day. Hey, we already mailed you a ballot. We're not giving you another one. Okay, I need to vote. I don't have that. Okay, we'll give you a provisional. We'll only count the provisional if we need to. And in the event we can confirm your other ballot hasn't also already been received. So it's like a makeup plan B ballot kind of a thing. For example, an in-person voter who is unable to produce the required ID at the polling place or whose registration cannot be verified may cast a provisional ballot. Likewise, for a voter who requests a mail ballot who is not shown on the district register as having voted, which occurs when the voter never returned their mail ballot package to the board. Now, the election code, however, unambiguously directs a provisional ballot shall not be counted if the elector's absentee ballot or mail-in ballot is timely received by a county board of elections. There it is again. If it is timely received, you want to think that if it is not timely received. No, it is. You're not allowed to count them. Like it's unambiguous. Respondents and others reside in Butler County. They submitted mail-in ballots. They failed to enclose their ballots in secrecy envelopes. Instead, they just put their ballots right in the mail. So then, upon receipt, the board did not know that Gensler and Mattis had failed to use the secrecy envelopes because in accordance with the election code, it does not open the mailing envelopes until election day. But the board weighed the mailing envelopes and reached a tentative determination that they didn't use the envelopes. The board then logged the receipt of the ballots in the system called SURE and entered a code indicating the determination that no secrecy envelope was present. So here's the stuff where they just put them back in. Schur then sent Gensler and Mattis emails informing them that their ballots might not be counted because they missed the envelope. Now, if the board had subsequently opened the envelopes and found that they were present, it would have counted the ballots. But they didn't wait for the board's determination. Instead, they cast provisional ballots during in-person voting on Election Day. Now, the board, however, did not count those ballots because it's well settled that provisional ballots cast by individuals whose mail ballots had been timely received cannot be counted. That's the example. Even if the mail ballots were invalid. And so the Commonwealth held that in 2020. So then, after the board informed them that their provisional ballots were not counted, they sued. What do you mean? They argued the election code obligated them to count their provisional ballots. Then applicants intervened to defend the board's decision, and the Democratic Party moved to intervene. So now they got two ballots that are out there. Okay, they got a mail ballot, and I'm guessing this is all orchestrated, right? They're looking for these situations. So they get a mail ballot, then they go and they vote in person, and they're saying the in-person vote should count. And they didn't do that. So Democrats sue. What? You're disenfranchising us. You already got a ballot. It's in your mailbox. I don't have it, so I have a right to vote. The trial court rejected their arguments, saying the election code unambiguously prohibits individuals who submit mail ballots that are timely received by election boards from having their provisionals counted. Commonwealth reversed, declined to follow the rule. Instead, it deemed the election code ambiguous. The court just came in, changed it, and reversed. Then the Supreme Court in Pennsylvania affirmed that on different grounds. The majority said the election code prohibits counting a provisional ballot if the ballot is timely received by a county board. But it explained that a prior decision had referred to mail ballots without secrecy envelopes as void. It then relied on the definition of the word void, a term that never appears in any provision of the election code, to conclude that mail ballots without secrecy envelopes never existed as a matter of law. So the courts just said, well, we don't really care about envelopes. Thus, the majority said that the mail ballots without secrecy envelopes were never received in the first place. And so you can see this mental gymnastics that this judge went through. That issue is true of all other ballots that violate the mandatory rules, like those without valid signatures or dates, all because these ballots are never, quote, received. And anyone can cure this. So other judges dissented in that opinion. Because their mail ballots were indisputably received by the board by the deadline, the election code prohibits their provisional ballots from counting. It's a policy choice, and so you don't get to reverse it. And the justices criticized the original decision there. Now, although Butler County Board of Elections is the only county board that is a party to the ruling, other 66 county boards are expected to adhere to the Pennsylvania rules. And they issued guidance to mandate they do. And so we're now here. Election day is right around the corner. And apparently, if the Pennsylvania Supreme Court ruling remains in place, county boards will be forced to ignore the election code, which says do not accept them, and count provisional ballots cast on election day by those who submitted defective mail-in ballots. So I guess there's going to be questions about whether they're double counted. Now, county boards may start counting provisional ballots on election day as it stands right now. And so you should grant this, Your Honors. This court will grant a stay if it's likely that 4 of you will agree with us and will win in a victory. A stay is warranted because they're violating the Purcell principle alone. Here, the Pennsylvania Supreme Court dramatically upended the rules. They established a cure process for all mail-in ballot errors after mail-in started and less than 2 weeks before the election. So all of this should be stayed. The majority decision should restore the status quo. A stay is warranted also because you're going to grant cert and you're going to find in our favor. Under any standard, their interpretation of the election code is not even remotely plausible. In fact, they've interpreted it to be the opposite of what it actually says. This question is tremendously important. In recent Pennsylvania elections, tens of thousands of ballots have been rejected for violating the rules, and now they'll all count. And voters got no mulligan in those elections. In 2020, under the General Assembly's plain directive, about 1% of returned mail ballots were not counted because of secrecy envelopes. That's a big number. Rejection rates for missing signatures and dates have varied, but each type of error could disqualify over 10,000 ballots. Now, thanks to the Supreme Court's decision, those individuals get a redo. They get a provisional ballot. They can just show up there and vote again. Because Pennsylvanians voting by mail already get notice of mail-in ballot errors, tens of thousands of provisional ballots that are flatly illegal under the code are likely to be counted. That outcome risks tainting or even flipping the result of the election in Pennsylvania, including the state, including the Senate race, and others. This is unacceptable, Supreme Court. Now, furthermore, failing to correct this would send a strong message that the Electors Clause is toothless and state courts can do whatever they want. Equitable considerations also favor a stay. Public interest favors a stay because we want fair elections. And finally, at a minimum, the court should order that provisional ballots cast by individuals whose mail ballots were timely received but defective be segregated from all other ballots and not included in the official vote tally. Court already took that step to prevent a similar case from becoming moot. And so all of this is going up to the United States Supreme Court. You can see a lot more details here in this brief, and it's being sent in there by John M. Gore out of Washington, D.C., the Gallagher firm out of Pittsburgh, Pennsylvania, and more. So going up to the Supreme Court, we'll see what they say about it. A bunch of other people have submitted briefs here, including the American Center for Law and Justice, Pennsylvania county officials, former government officials, Democratic parties involved. And so we'll keep our eye on it. We'll see what the Supreme Court does. They granted relief in Virginia. Hopefully they do the same in Pennsylvania, because the courts should not be allowed to interpret a statute in the exact opposite manner in which it was written, as they're trying to do here. But that's how they stole it in 2020. They're working hard again this time. We'll be here continuing to cover this, my friends. Thanks for subscribing, sharing our channel, and joining us as we do. We'll see you back here on the next one.